there was a partnership agreement which was registered document which provided that arbitrator is to be appointed by mutual consent. That was registered document. The clause was that no clause can be modified unless a separate deed is executed. So that registered separate deed is executed to modify. Now what they did is, on a letterhead of partnership, they have modified that clause so as to suit their appointment, where they have given right to themselves, 3 family members, to appoint an arbitrator. And without any disclosure, we have straightway, without any requisition, we have straightway received notice from a lawyer that he is being appointed as an arbitrator. There is an interim claim.
No, where is the agreement? First agreement?
First agreement, my lord. Translated copy is at page 31A, my lord.
Huh?
31A. 31A is translated copy. And my lords will find clause at 31J.
This is the partnership deed.
Yes, this is partnership deed between 5 partners, 3 from one family and 2 from other side. Now 31J, my lord, clause 20 and 21 is very relevant, my lord.
Page number?
Page number 31, capital J, my lord. There, clause 20 says, if amendment in any of the condition, from condition number 1 to 28, it is by mistake, in original it is 28, is to be made, then amended document is to be done. And if amendment is to be done in other condition, then it will be done orally by partners. Now further 21, my lord. If any dispute arises with regard to interpretation of the condition, there is some, my apology, I will correct that translation. Of the condition of the partnership deed arises, then the redressal can be done with mutual consent of partners with the appointed arbitrator, and at that time provisions of so and so will apply. Now this is registered document saying that no condition can be modified. Now kindly similar to what they did is, on a letterhead at page 33.
No, 1 second.
Further also, my lord, arbitrator at page 25 also does not provide that majority can appoint. It says arbitrator. Therefore, by mutual consent, it would mean page 31L also, my lord.
Yes.
And now, my lords, may kindly just have a look at the document which they executed it as page 33. On a letterhead, these conditions are modified with a stamp paper attached. Page 33. And I will take your lordship to translate copy, but just to show that this is done. This is how the condition is modified. Page 33B, my lords will find the translation of this.
You are not a signatory to this?
This is a letterhead which was lying in the premises only as
it says 33 says 100 rupees non-judicial stamp paper.
That is, there I am not signature.
Huh?
There is no signature.
Your name is there at serial number
Only
6.
name is there, first page, there is no signature. No signature is there. And last page, which the letterhead of the company was lying for convenience of business, is used to modify. And a registered document being modified through a letterhead.
No, registered where?
This partnership deed was registered before sub-register.
Sub-register?
Yes, ma'am. It was a registered deed. That is at page 30. My lords will find registration also.
Which act provides for registration of a partnership deed before the sub-register?
As such, partnership deed doesn't even require registration. I am not on that point. But when the document is executed, which is registered where condition is provided, my lord, that if there is any change in the document, it has to be done through valid document. This is not even notarized. And therefore,
you appear only on criminal side?
Yes, mainly.
Huh?
Mainly.
Have you read Partnership Act?
I have read, my lord.
Read section 58.
Under 10 also contract act, my lord. In a moment, yes, it requires. It requires.
It requires registration, not under the sub-register.
It requires.
Sub-register has no authority.
these document will go to the registration, but first it has to be executed and then it will go, my lord. But then that is, I am obliged, my lord, that point will favor me, my lord, because what they did is on a letterhead, they have just changed the condition of a document which is otherwise registered notarized document.
Are you a signatory to that supplementary amended partnership deed?
I am not signatory. If my lord sees page 32,
Where is the original?
I'll just explain, my lord. Page 32. This first page is not signed by me. Page 33, it is a letterhead of the firm on which this is annexed. Therefore, it is tampered with, and this letter, this stamp paper is misused, my lord. That is my case. And therefore, my lord, I am saying it may be appointed with mutual consent. They have unilaterally appointed some advocate who has not even given any disclosure under 12. And the prayer is that we should be allowed to sell property to third parties. That is interim prayer before the arbitrator. And kindly see, my lord, no notice, no requisition under section 12 is issued. Nothing has been done, my lord. If your lordship sees, even simplicity or allegation of fraud will not be sufficient, but the court have taken a view that when there is an allegation of forgery, my lord, then the court, it will go to
What is your prayer here?
My lord, my prayer is that and any arbitrator of honorable court's choice be appointed.
Where is your prayer?
Yes, ma'am. Prayer to appoint sole arbitrator under 11(6) of the Act to adjudicate the claims so and so, and to hold and declare that the appointment of.
Can this prayer be granted?
Well, 11(6), now the scope has been expanded, saying that it will also cover this also. It can.
Which is that?
Yes, that I have annexed that judgment, my lord. It can be, my lord. Page 319, my lord, if my lord sees one judgment, there are 26. The further question that arises whether the power can be exercised by this court under Section 11 of the Act when the appointment of an arbitrator has already been made by the respondent, and whether the applicant should be left to raise challenge at an appropriate stage in terms of the remedy available in the law. Similar controversy, then the court is there on the page 337, first three lines. Para 10, may I read at page 336, last three lines. Unless the appointment of arbitrator is ex facie valid, and such appointment satisfies the court exercising jurisdiction under 11(6), acceptance of such appointment as fait accompli to debar the jurisdiction under 11(6) cannot be countenanced in law in the present case so and so. Here arbitrator is.
Sir, there he preempted the notice which was issued on 29/7.
Lodge.
They said they appointed an arbitrator saying that we have a right to arbitrate, appoint an arbitrator, and appointed. So that was the interpretation. Here is a question of fraud.
And same.
You are
same thing.
pleading, but you are contending that there is a insertion made,
Insertion.
fraud perpetrated.
Lodge.
And by virtue of fraud, whether we can go into
Yes,
that.
that is the direct decision. Is
Show that direct decision.
Yes, my lord. Yes.
Show that direct
Page
decision.
253, my lord.
First you said this is the direct
No,
decision.
this is where under 11(6) the appointment can be set aside.
And what is the prayer in this petition?
Miller to set aside his appointment and appoint an
No,
arbitrator.
in this justice, where this HCC versus Parkinson.
Miller,
Eastman.
there was architecture agreement between.
What is the prayer?
Prayer was below to quash the appointment under 11(6).
Please show,
Yes, Miller, that was
show
there.
that.
Where-
Popat, you
where
should,
338.
huh?
338. Para 30. Same has happened in my case also. By letter I am informed that you have been appointed as an arbitrator, and that person, my lord, who is a lawyer who has been appointed as an arbitrator is appointed unilaterally by them.
There was no prayer.
My lord, the court has.
They have
because-
annulled it.
Yes, they have annulled it. Therefore,
There was no prayer. We said, there was there any prayer? Come to page number?
my lord, but appointment was annulled under 11(6). So ultimately, my lord,
No, it was not under 11(6).
I am trying to satisfy my lord that under 11.6, my lord, their appointment can be quashed and a new arbitrator can be appointed. That is what I am trying to, my lord, drive it before your
Then
lordship.
we'll consider.
Then-
We'll admit this petition, we'll hear
My lord,
it.
one last judgment, if it appeals to my laws, because I'll be in my law's hand, whoever arbitrates, my lord, not this person, because kindly see, my lord, out of this arbitration, all through judgment says that is a bilateral act. If there is no intervention of the court, it has to be bilateral act. Suppose court appoints any person, I cannot object to it. But a private party appointing private advocate and that advocate without any intimation, just sending a letter to me that I am an arbitrator, I have received an application for interim relief and I will consider this application, therefore you appear before me. There is a problem, because there's a private person. Kindly see page, therefore I was showing judgment on forgery also, which I have annexed, only one judgment, page 253, because it starts at page 250. 253 may be seen. Para 9, my lord. Can I skip after 4-5 lines at page 253?
Yes, which para?
Para 253 page, para 9, last 5 lines, my lord.
Yes.
There it has been stated that where there are two categories, one is simple fraud and one is fraud with allegation of forgery. When that allegation is made, merely fraud is not enough, but if allegation of forgery are there, then that goes to the root of the matter, and the courts have taken a view that it can't, because then otherwise it will be.
So what? What is the consequences of it? Under 11.6, can it be examined?
Yes, it is under 11.6 only. The court has said
What
that
was the fact here?
fact were different, my lord. I'm not.
Tell us in nutshell.
Yes, in this case, my lord, there was a case where a partnership deed was there between parties. Now family partnership. By another deed, the percentages were reduced of one partner. That is what, if my laws finds para 4 at page 50.
What is the relationship between the parties?
They were a grandfather and their heirs. That is what the para 4 is there, where these facts are quoted. I have the note also. I can pass on to your lordship. Grandfather died. Grandfather died, and on after 50%, they have reduced it to 25%. That was the question before, and there the forgery allegations were made that this reduction is false. Now, in that background,
after making a forgery, then who applied for arbitration?
The same case in my case, the other
who
side
applied for the arbitration?
the other side applied for
Which other side means which side?
in this case, respondent applied. Now, in this case, page 253 maybe
Sir, we'll come to that.
Lodge.
Every case law
Lodge.
is based on the facts.
I am only on simple point where the categories have been said that if there is a fraud.
Sir, in none of these cases,
Lodge.
the apex court has held you can set aside the appointment of arbitrator.
That has been done. Kindly, can I, read that passage?
There, that was a case where you have not read the facts.
No, there it has been done, on this ground only.
Then tell us the facts.
On this ground of forgery, facts may be different. I am not on facts. I am saying that it was.
It all law depends upon facts.
In this case, I will show it's very glaring, because kindly see, what has happened is a registered document which contain a recital.
All right, we'll admit. Heard, admit. Who is on the other? You are there in the other side?
Yes, I am for Mr. Dabi.
File your statement of objections. Objections, if any, shall be filed. Post for hearing in 3rd week of October.
Please, lodge. Oblige.
For final hearing.
Please.
Number 21.
Can we seek adjournment, or my lords? Can we seek adjournment, because
You do whatever you want.
Lodge.
You can seek even interim measures also under section 9.
No, they have sought to sell the property to third parties. That is what they are seeking.
Huh?
They are seeking that we should be allowed to sell the property.
By filing section 9.
Yes, they are seeking.
You file one more section 9.
It is now that person has not even given disclosure that he has personal interest or not. We have sought for that also.
You file one more section 9. Is there any prohibition for
No,
any
there is
party?
no. There
to
is
file?
no. We will do that.
Any interim measures, injunction, prohibition to protect and preserve the property during the pendency or after the.
I only want status quo. Whatever is there should remain. They want to sell it. Then third party rights are created. Then there will be.
Go before
Lord,
civil court.
We will file that application. Lord.